you all for joining us today. To get us started, Kara Brodfehr will conduct a roll call.
Thank you. Chair Mendelbaum?
Present.
Councilmember Brodsky? You're muted. Yeah. Okay. Present. Councilmember Iglesias?
Present.
Councilmember Ortiz?
Present.
Councilmember Sandoval?
Present.
Councilmember Scher?
Present.
And Director Kish, you could just raise your hand if it doesn't work. Okay, I think we have everyone.
Well, thank you all for joining today. Today's hearing will examine California's Fair Chance Act and the use of criminal history in employment decisions. This hearing will be an opportunity to highlight the history of the act and the significant need it sought to address, namely removing unnecessary barriers for the gainful employment of community members with criminal histories. The hearing will also examine the current state of academic research concerning employment opportunities for formerly incarcerated individuals and highlight the challenges that continue to exist in California and identify and examine potential statutory, policy, and other practical changes that can be made to better effectuate and advance the purpose of the Act. Finally, the hearing will serve as an opportunity to provide guidance for employers, job applicants, and other members of the public on the resources that are available to ensure enforcement of and compliance with the rights and responsibilities under the Act. A couple of preliminary items before we launch into our program. First, I want to extend a huge special thank you to our partners in planning this hearing, Legal Aid at Work, and in particular, Katie Dixon and Stacey Villalobos. We couldn't have done this without their ideas and resources and tireless commitments to this process. So we really appreciate the partnership. I also want to extend my personal gratitude to my colleague on the subcommittee, Councilmember Gabriel Sandoval, who put in a tremendous amount of work to bringing this to fruition, and to Adam Romero and Kara Brodfehr, the department, for their work putting this tremendous program together. Finally, this will be the last council meeting of our colleague, Councilmember Joseph Ortiz, because on November 13th, Councilmember Ortiz was appointed by Governor Newsom to serve as a judge in the San Bernardino County Superior Court. So congratulations once again, Councilmember, soon Judge Ortiz. We're sad to lose you and your contributions to the council, but also very happy for you and know that you'll be a tremendous addition to the bench. So congratulations. A few logistics notes. Remember, for those of you that have participated in prior Zoom meetings of ours, you are currently on mute and your video is disabled. However, you will have the same opportunities of all of our in-person meetings to provide public comment during our public comment periods that will be at the conclusion of each of our presentation sections during the day. And you can do that through a couple different means. You can utilize the raise hand function in Zoom, which will allow you to make your comments directly by video and orally. You can also submit written comments either by utilizing the chat function within Zoom or by emailing the council at fehcouncil@dfeh.ca.gov. For those who would benefit from closed captioning, you can utilize the button at the bottom of the Zoom function that has the CC and will allow you to use closed captioning and has a number of additional options available. You can also check the chat box, which has a link that will allow and facilitate the closed captioning functioning and assist you in that process. You can also chat the administrator who can connect you more directly to those providing the closed captioning if you need additional assistance with that. So without further ado, we'll get started with our first panel of the day, and I'll turn it over to Deputy Director Adam Romero. Deputy Director Romero was appointed by Governor Newsom on March 5th to be Deputy Director of Executive Programs at the California DFEH. He's an expert in anti-discrimination law and multidisciplinary research and leads the department's Executive Programs Division, which includes teams in the areas of legislative and regulatory affairs, research and reporting, outreach and education, Appeals, and Public Records Act responses. Prior to his appointment, Deputy Director Romero was the Arnold D. Cassoy Scholar of Law and the Director of Legal Scholarship and Federal Policy at the Williams Institute at UCLA School of Law, where he was an adjunct professor and faculty affiliate of the Critical Race Studies program. A native Californian, Deputy Director Romero received his AB from Cornell and graduated summa cum laude. After that, he received his JD from Yale Law School. Prior to law school, he was an investigator for the Bronx Defenders and a community organizer in New York City. So, Deputy Director Romero, I'll turn it over to you.
Thank you, Chair Mandelbaum, and good morning, everyone. I'm the moderator of our first panel this morning, which will be addressing the need and the promise of the California Fair Chance Act, but also challenges and opportunities to advance and improve upon the goals of the Act. And I'm joined by three panelists who are true experts in this area. First, we have Sandra Johnson, who is the in-prison coordinator at Root and Rebound and a proud member of All of Us or None. Prior to joining Root and Rebound, Sandra was a community organizer at Legal Services for Prisoners with Children, LSPC, and she started at LSPC in 2017 as the first Elder Freeman Policy Fellow before joining full-time as an organizer, becoming one of the senior organizers for LSPC. Sandra worked on California's Ban the Box law and testified before various legislative committees. Our second panelist is Jennifer Tilton, who is a professor of race and ethnic studies at the University of Redlands. Her research explores the ways racism shapes criminal justice policies and practices and how fears of crime have reshaped our communities and politics. Over the last 5 years, she has had the pleasure of working with a broad coalition of reentry service providers and directly impacted people in the struggle to take down barriers to people with criminal records that people with criminal records face in our communities. She is a facilitator of the Inland Empire Fair Chance Coalition in San Bernardino and Riverside counties, which advocated for the passage of the California Fair Chance Act and works to advance fair hiring in inland Southern California. And third is my colleague at DFEH, Brandon Butler, who is our Assistant Deputy Director of Education and Outreach. Prior to joining DFEH, Brandon was the Senior Attorney of the Fair Housing Center of the Legal Aid Society of San Diego, where for 9 years he was instrumental in creating a housing services program that provided education, outreach, testing, and enforcement of fair housing laws. Brandon also has led numerous broad-based fair housing education campaigns, as well as specific campaigns addressing discrimination against people with mental health disabilities and source of income discrimination. Brandon is a native of California and graduated cum laude from Thomas Jefferson School of Law and earned his BA graduating magna cum laude, California State University, Chico. And let me ask the three panelists to please unmute themselves. And our discussion this morning is going to be broken into sort of 3 parts. First, we're going to be talking about how did we get here and what is the Fair Chance Act? Second, where are we now and what kind of organizing is happening and what are we learning from the ground? And then third, what are the challenges and opportunities to improve the Fair Chance Act? Or what are challenges for people with individuals with criminal histories to gain employment, and what are the opportunities to improve and develop this area of the law and the surrounding context. Before we get to the Fair Chance Act, I'm just going to try to show a video. If you just give me one moment to bring it up. Sorry, one moment, my computer's having a few difficulties. let me bring, while I turn it over to our panelists, I'll bring up that, that video in a moment. But first, let me ask Sandra Johnson, this was I think personal, how you came to this was, very personal. And I want to sort of invite you to share with the group how you came to work on the issue of Ban the Box and your organizing around this issue.
Good morning, everyone. And thank you for having me on this panel. So what drew me to this work is that I really honestly had to learn how to advocate for myself once I was released from incarceration. When I was first released, the last time I was released from prison, I promised myself that I was going to do whatever it took in order to, stay out of incarceration. And even though I recycled in and out of incarceration for over 15 years, the last time I just really wanted to do something different. So I relocated from my hometown, just because I thought I was going to start over. So I came directly to San Francisco Treasure Island program. And once I started looking for employment, I started to feel the real struggle of coming back from incarceration and into society, and how unforgiving it was. And I'm just gonna really be honest with you. It was really hard. I had to apply for over, I think I applied for over 50 jobs before I was given a chance, before someone gave me a chance at employment because of that box. Every time I filled out an application, I had to be honest on it. And when I checked it, I never got a call back. It just was really, really super hard for me. Finally, I got a job as a paratransit driver for a company in San Francisco. And I worked there for about 6 years. I drove elderly people back and forth to dialysis. So I really loved that job. When I got that job, I was so excited about finally given a chance to be a law-abiding, tax-paying citizen. And so, I put my all into that job. And then after 6 years, I was fired from that job because of my criminal history. When I said I put my all in that job, I worked on days that I wasn't supposed, that when people didn't show up. I did a lot of extra stuff. I worked on Saturdays, I worked on Sundays. I did, I eventually won Driver of the Year and Employee of the Month. And that's how much hard work that I put in that. And so after working there 6 years, they fired me. And I was really devastated. It kind of felt like the rug was put out from under me because I had my own apartment. Finally, I was working, I was staying out of trouble. I had gotten off parole. I did a lot of work on myself. I had went through therapy, and then they fired me. So it really felt like they had put the rug out from under me, and I was scared. So I just started going around, talking, because I didn't want to go and apply for another job because I kind of felt marred. I kind of felt slighted or different. So I met this woman that was doing fair housing in San Francisco. She was working on fair housing, and she invited me to a town hall. And I went to that town hall and I spoke. And I spoke about, the opportunity of, or the issue of giving people with criminal backgrounds a chance. And after I spoke at that town hall, don't ask me what I said because I was nervous. That was my first public speaking. I was given all kinds of cards. People came up to me and gave me their cards. And this one particular card stood out to me. It was from all of us. It was from a formerly incarcerated membership, All of Us or None. And that kind of stood out to me because it was a membership of formerly incarcerated people. And so I started going to their meetings and just listening to what they were talking about. I really didn't speak at the meetings, but what I heard was that we shouldn't allow people to hold us hostage to our past. And so that's where I first, and they were also, when I started volunteering at their office, and they were also working on an initiative of Ban the Box. I think it had passed in San Francisco, but I was all new to all this. So I just would look, like, hear bits and pieces, and they were advocating, they started advocating for Ban the Box, and it just spoke to me. And a fellowship came up, and I applied for the Elder Freeman Policy Fellow, and that's how I started testifying for Ban the Box, because I had the story. I was passionate about removing that off of the application and giving people to go work at. Guess that's that. Did you hear me? Hold on.
Thank you, Sandra. I guess all things sort of happen for a reason. I'm kind of glad that the tech issue happened, because your personal experience and story so animates the importance of the Fair Chance Act, and I think illustrates why this law has so much promise and is important. So let me now share this video. It's a video produced by the Department of Fair Employment and Housing, starring our very own panelist, Brandon Butler, on the Fair Chance Act. And we wanted to show it at the outset to help everyone have a sort of a baseline understanding about what the Fair Chance Act does. So I will now share this.
Are you worried about how you're going to get a job when you return home, or whether employers are even going to consider hiring you? This is what California's Fair Chance Act is all about. Let me tell you about it. When you go home and look for a job, you have the right to be judged on your work qualifications, not your past. My name is Brandon Butler, Assistant Deputy Director of Education and Outreach at the California Department of Fair Employment and Housing, California's civil rights agency. In California, we believe formerly incarcerated people deserve the right to participate in their community as a thriving member with access to employment, housing, and community resources. If you were locked up and did your time, you should not be locked out of society when you return home. That is why, under California law, it is unlawful for employers to ask or include a question about conviction history on a job application or ask about a past conviction prior to a conditional job offer. That means an employer can't ask you about your conviction history or run a background check until after they've already offered you the job. Remember the box on the job application that used to say, "Have you been convicted of a felony, yes or no?" Well, that has been banned. We banned the box in California. An employer can ask you about your criminal history or run a background check after they offer you a job, but they still have to follow some rules. The employer is never allowed to ask about things you were not convicted for or convictions that have been expunged or sealed. If you've been pardoned or received a certificate of rehabilitation, the employer can't ask about that either. If the employer wants to take back the job offer after the background check, that can only happen after the employer conducts an individualized assessment. That means the employer has to consider you as an individual person. They have to consider the time that has passed and how the crime you were convicted of is related to the job you applied for. If the employer is still going to take back the job offer because of your history, they need to send you their decision in writing, listing out the convictions they think disqualify you and provide you the conviction history report they base their decision on. Then you get 5 days to challenge the decision. For example, there might be something in the criminal report that's just wrong, or you can provide information to change the employer's mind, such as information about your work history, special circumstances that help explain your past crime, or education or training you've received. In other words, evidence showing that you can do the job and that your conviction history isn't relevant. If the employer is still going to take back the job offer after considering all the evidence, it has to be because your conviction history has a direct relationship with the specific duties of the job. For example, if a person was convicted of a felony traffic offense while driving a car, Their conviction history would have a direct relationship to a job as a limousine driver. If the employer takes back the job offer, they need to let you know in writing that you can file a complaint with our office, the Department of Fair Employment and Housing, if you believe your rights were violated. At the Department of Fair Employment and Housing, we are here to help, and it's free. Call us at 800-884-1684 or TTY at 800-700-2320 or California's Relay Service at 711. Remember, we have banned the box in California. In California, you have a right to a fair chance to get a job, and the Fair Chance Act protects you. Thank you.
Thank you. So I want to turn now to Professor Tilton and ask about your work with the Inland Empire Fair Chance Coalition, which, as I mentioned in your bio, helped advocate for the passage of the Fair Chance Act. What drew you to the work of the coalition, and what led the coalition to advocate for the act?
Yeah, thanks for the question. IE Fair Chance Coalition first came together in 2016 with the leadership of a number of prominent reentry organizations in the Inland Empire, Starting Over, Time for Change Foundation, also Riverside, All of Us or None. And our activism really grew out of the same frustrations that Sandra was talking about, seeing folks coming home from prison and jail and getting turned down over and over for jobs. Actually, in the logistics industry, which is really prominent in San Bernardino and Riverside, people were often able to get jobs in temporary positions in warehouses, but they would get fired right after they applied for permanent jobs with better pay and benefits, right after the background check was done. So for me personally, as a scholar of racism in the criminal justice system, these employment barriers were also fundamentally a racial justice issue. Too many Black, Latino, and Indigenous people have been swept into the criminal justice system and then stuck with that felony label, which then seems to legitimize employer discrimination and to compound the already huge problem of racial discrimination in hiring. So when we came together, California had already passed the first Ban the Box law, AB 218 in 2014. That only applied to cities and counties, but some of our local advocates wondered if it was really making a change in hiring policies. So in 2015, Kim Carter from Time for Change Foundation asked me and my students to do some research into whether that law, that Ban the Box law, was working to open opportunities for people with records. So we kind of called city and county HR departments and asked them about their hiring policies and practices. And we actually found that almost no cities or counties, with the exception of Riverside County, had developed any clear policy or training to make sure they were in compliance with that early law. And some would just say flat out to us that they didn't hire anyone with felony records. So then we began as kind of a coalition to begin meeting with cities and counties to say, look, you have to change your policies. This might be violating the Civil Rights Act, and here's why. And we faced a fair amount of resistance. One county official, even elected official, I'll point out, even said explicitly, you don't mean we actually have to give people with felony records a fair chance at employment. So we got pretty frustrated with the slow pace of local change. And Kim Carter began networking with people statewide to see if we couldn't win a more ambitious and detailed Ban the Box law that would make our local advocacy work easier. So a lot of our coalition members lobbied hard to secure the passage of AB 1008. We met sort of weekly with legislative aides leading the campaign. And so, we saw some of the ways advocates had to compromise to get the bill passed. For instance, so the Chamber of Commerce would pull its opposition. Just kind of as one example of one of those compromises, in the original version, we had fought for kind of strict look-back periods. Some of you might remember, 5 years for misdemeanors, 7 years for felony convictions, because we hoped we could at least create a clear end date for when criminal records would no longer be considered. And that part kind of got lost in the negotiations. So we could win the law. And we were kind of thrilled despite those compromises when it passed. And in some ways, our coalition kind of sat back and we were like, yay, we won this thing. This is great. Now, the members of our coalition who had criminal records could be judged for who they are now, not for what they've done in their past. But I guess in the years after the passage of AB 1008, we kind of found ourselves right back in that same position we were after AB 218 passed, wondering how much had our local employers actually changed their policies to be in compliance with the law. And that sort of got us engaged in activism again.
Thank you. And I want to bring in Brandon here. As I mentioned in your bio, you worked as a fair housing attorney before joining the Department of Fair Employment and Housing and doing eviction defense work. And I wondered if you could describe how your work at the Legal Aid Society relates to the Fair Chance Act and how criminal history is used by housing providers to deny housing to folks.
Yeah, thank you, Adam, and good morning, everyone. It's a pleasure to be here this morning. Yeah, so I have been working in the housing arena for many years, and I also first say the issue of the Fair Chance Act and the issues of the barriers to employment really came as when I represented clients in an eviction proceeding who had a past criminal history, and seeing that there was great need to try to resolve the case because it would be so difficult to obtain housing with a past criminal conviction, and through reading about and working with them, understanding the barriers they face in employment, and how, or even a family member who had been incarcerated, what that would do for housing, the difficulty of ever finding housing, really brought that message home to me. And so I worked a lot with clients who were facing this challenge. So it was something that was on my radar. And then in 2016, HUD provided some guidance around a criminal history review in housing. And in my fair housing work, this became an issue where I saw, again, because of the disproportionate incarceration rates for people of color, that in housing, you're seeing a situation where people were being denied housing disproportionately based on race because of a past criminal conviction. And so seeing the relationship between the barriers to getting a job, and if I can't get a job, then it's a challenge to get housing. And then if I have a criminal conviction, I can't get housing. Seeing this cycle to me was really a key component to its relationship to the employment side of the house. And so that's why I think what we're doing here today is so important, because the Fair Chance Act really gives a process by which folks can be judged on who they are, not their past. And the relationship between that and housing was ever present. And then in addition, in my work as doing fair housing work, when we would do testing is a process where we would send in a person of one protected characteristic, let's say a Caucasian person, then we would send an African-American person in and try to measure the differences to whether or not they would be able to obtain rental housing, right? Would they be charged higher rent, or what would happen? And one thing that we would see time and time again was when a person of color went in on the test to inquire about housing, the housing provider would ask about that they were going to run a review for past criminal convictions, and that they better be sure to have a clean record or wouldn't get housing. And so again, seeing the intersection between race and past criminal convictions colliding again in the housing market, and the same thing happening in the employment field. And so to me, I do come from the housing perspective. I think it just helps us inform, and kind of what brought me to this issue is seeing how much impact it had in housing and how much impact it's having in employment, but the Fair Chance Act providing some relief and providing some awareness of how to maybe develop a process, which we'll talk here about more about what can be done to improve it. But my coming to this issue really is from the housing side and seeing its impact as both used in intentional discrimination, as well as seeing the impact of having a preference for only renting to people without a past criminal conviction is having on our society, and the same would apply in the employment field. So I'll leave it there.
And on that note, let me just mention importantly that the Fair Employment and Housing Council, this body that we're in front of today, has issued regulations that limit the use of criminal history in the housing setting. So in some ways mirroring the process that exists in the employment context in the housing context. And though our symposium today is focused on employment issues, it's important to, I think, as you're describing the connections between employment and housing. I think that's also a perfect segue. Brandon, I want to stick with you to describe, as we move into sort of this second part of our discussion of where, what's happening today, if you could describe your work at DFEH around the Fair Chance Act, I think that'd be helpful to everyone. Thank you.
Yeah, no, well, thank you, Adam. I mean, so I I've been with the department now for a year and change. I guess it'll be a couple of years in April. When I first came to DFEH, our director, Kevin Kish, came to me and stressed the importance of that we wanted to do more on the Fair Chance Act, wanting to have an impact. And so, and since, again, coming to this issue and being passionate about it, we really have tried to develop a multi-pronged strategy to increase awareness and knowledge of the Fair Chance Act, and thereby having folks actually use the Fair Chance Act. So we've done some kind of coalition building, working with for example with Jennifer Tilton in the Inland Empire Reentry Coalition, as well as connecting with many regional reentry coalitions from the Bay to San Diego to the Inland Empire to LARP in Los Angeles to the reentry offices throughout city and county offices. So trying to build a connection, because believe it or not, many folks weren't aware of DFEH, that we actually enforce the law, that we're the place to go. So that really we're starting from the ground up, building coalition building. And then we've also connected with our stakeholders and folks who need help. For example, built a partnership with the Corrections Department, CDCR. In fact, the video we all watched was done in collaboration with the Corrections Department, and in fact airs on Inmate TV in all California state prisons. And so we have tried to connect with folks inside, and as well as training parole agents throughout California, because they're on the front line of seeing the difficulty of folks who are working with obtain employment. So we've been training parole agents and probation officers throughout the state on the Fair Chance Act, connecting with our community college partners, and as well as many of the stakeholders on the phone on this meeting today have been invaluable in the assistance that they have brought. So I just see the closed capture. Sorry. So we have worked on that level of building the coalition kind of side of building. And we've also engaged in trying to bring more educational material. You saw the video. We've also developed FAQs and fact sheets to help explain the law in more insight. And I wanted to share too that as kind of our building, we're seeing some change in terms of awareness and complaint filings. When in 2018 in our annual report, we had 62 cases filed for Fair Chance Act type violations, and this year in 2019, our latest report, we've had 137. And in our right to sue letters in 2018, right to sue is this process where you can kind of bypass DFEH and file your own employment lawsuit. And we had 8 of those in 2018 and 2019. We had 254. So some awareness is happening throughout the state, and we're just still at the ground level. But that is something that's showing some awareness. And so I think from my standpoint, and it's working with our partners, realizing that there's a large deficit in knowledge and understanding of the Fair Chance Act. It's a little bit complicated too, and so it requires kind of ongoing training. And I'll also share too, we're engaging in different types of educational means in terms of app development around the Fair Chance Act and other things that could be helpful to engage both employers and applicants for jobs. So I would say that's what we've been doing, what we will continue to do in this space around the Fair Chance Act, outreach and coalition building and education.
Thank you, Brandon. And I want to turn to Jennifer to ask sort of what's happening now on the ground in the Inland Empire, and what is the coalition doing to help advance fair hiring?
Well, we sort of, similar to Brandon, we came back together in kind of the summer of 2019 because we heard from all sorts of our members that employers were still asking the question up front, right? That a lot of employers in our region were not following the law at all. And also most reentry service providers and people with records didn't understand the ins and outs of the law. I mean, as Brandon mentioned, it's kind of complicated. And so people really didn't know how to advocate for themselves through the process either. So we developed this kind of wonderful coalition of directly impacted people, service providers, and now some county workforce development representatives. And we meet every week to kind of strategize about how to increase awareness about the law. We've collaborated with DFEH, with Legal Aid at Work, to do a whole series of trainings for employers. reentry providers, and people with records. And some of our members have also directly impacted members from Project Rebound at Cal State San Bernardino, have really tried to solve the problem of, even if you understand the law, like how do you get yourself ready to advocate for yourself with an employer, to effectively, you know, write that letter to say, hey, this job should be mine, and here's the packet that proves that I've changed my life. And so some of our members from Project Rebound have done some trainings for directly impacted people that really lead them through how do you write a good packet to advocate for yourself, and have that ready before you even apply for the job, so you can respond in that 5-day window that you've got. We've also been really actively training and supporting people to file complaints. That process, you know, it's not super complicated, but the first few times I helped someone file a complaint, I was lost. And so we really help train people to document the job process as they go, so that they can say, hey, is this a violation, and reach out to us for confirmation, and then we help them file complaints. And sometimes we actually file complaints as a coalition in our own name. Sometimes when people don't want to be named, or when we find the violation ourselves, because as a coalition, we've been also doing some active testing to identify complaints. And I think we've done this because we've realized we can't just wait for people to file complaints. The violations are kind of everywhere, and a lot of people are just not coming forward on their own. And so we have to actively kind of go look and identify some of the most egregious violations and bring them to the attention of DFEH. And so one thing we've done statewide in this arena is, with the support of some other for employment advocates around the state and a very tech savvy advocate, we've developed a kind of protocol to pull a lot of job ads from Craigslist and ZipRecruiter, and evaluate them for violations of AB 1008 right there up front in the job ad, so before you even get to the applications. And we find a lot of employers in California, we did this summer, so a lot of employers are still using language in job ads that actively discourage people with criminal records from applying. Many say simply no felonies, or slightly more ambiguous, must have clean record. And it's clear, like, when employers are saying that upfront in a job ad, they are not doing the individualized assessment that AB 1008 requires. Even more employers use more subtly exclusionary language, like must pass background check. But I want to be clear that, you know, we hear from our members who have criminal records that that kind of language operates as a really clear signal to them that they shouldn't apply, right? That discourages people with records from applying. Because what does it mean to pass a background check? It's not just to do one, it's to pass one. So we've actually sent letters to all the employers we found in California with Craigslist ads that seemed to us to be violating the law. Some responded politely and clearly didn't understand the law at all, and so we did some education with them. Others were a little bit less polite. And when we checked back this fall, some of the serious violations are still there. So some of our volunteers and interns are beginning the process of filing some complaints about just those job ads with DFEH. So that's just some of the things we've been doing.
And let me bring in Sandra now, because you've continued to work on these issues since passage of the Fair Chance Act. And I wonder if you could describe your work at Root and Rebound and what you're seeing with the clients that you work with.
So my job at Root and Rebound is an in-prison program coordinator. And this means that we were going into 2 institutions, but now we're just going into 1. And it's me and my coworker, and we do I haven't been in so long, we do a 5-part, we educate the incarcerated people about employment, housing, education. So we educate them with their rights about, well, one of my passions is to let them know that, you know, in employment, or how, you know, I talk about gaining employment with a criminal record. So I tell them how to do their resume, how to use their job inside, on how to build up their resume. I also tell them my struggles of getting a job, and I also tell them that you have the right to have a job. So if you feel that an employer is discriminating against you, to say something. And I give them people that I've talked, you know, I gave them organizations and companies that I've talked to, like Legal Aid at Work. I've told them about EEOC. I've told them, you know, that's what I do. So Jamie goes in again, she does the legal part of reentry, because there's thousands of barriers for people that's coming from incarceration. And one of them is to a job. So, that's what I do. And then I give them the practical part. I think, you know, whenever I think about my job, I just give them the strength and the hope and I teach them to push through all this muck that we have to go through coming out of incarceration. So that's what we do. We teach them about employment, housing. We just teach, and then what I do at the end, this was a new job for me. So we formed a blueprint, and we asked them all kind of questions that they, you know, pertaining to a personal reentry and what they need. And then what I do is, because when I came out of incarceration, it was so much stuff that I had to like push through. I try to send them from their personal blueprint a resource package for things that whatever county they're going to, like if they need transitional housing, we send them food banks, we send them low cost free medical, you know, in their area. We also send them all the libraries in their areas. I teach them that they can go to the, you know, computer labs there, and they can, you know, upgrade they can, you know, hone in on their computer skills there. And we send them all in their area, wherever they're going to. We also send them all kind of like one stop. They used to call them employment offices or one stop. And I try to build I'm trying to build like warm handoffs for different areas where, you know, where people are open to hiring people with a felon, where employees are open. So I'm trying to build a network where it's easier for them to come out and make it, you know, for out of incarceration. So.
Thank you. And let me turn the discussion now to ways in which the law and the surrounding context could be developed to increase opportunities for employment opportunities for individuals with criminal histories. And to both Jennifer and Sandra, first, I wonder if you could describe some of the barriers that you're seeing out there. I mean, I think you both already, and Brandon as well, have mentioned some of those, but to highlight those again for the council, and then also to think about also, what are some of the barriers to people filing complaints with DFEH? And then I would like for us to turn to ways in which maybe the council or the legislature or others could develop the law in a positive direction.
Okay, so I'll start. So I think we've seen some specific areas, including kind of kinds of employers that might need more focused training and guidance or monitoring from DFEH. So for us, you know, we see staffing agencies as an area where there's still a lot of ambiguity. They're often skipping the formal conditional offer stage, and they sort of have people fill out an application that includes all kinds of questions about criminal backgrounds. We recently filed a complaint about one of these, and the staffing agency defended itself saying they only asked the questions after they were hired, but it wasn't at all clear to the applicant that they had been hired. And they hadn't been offered a job placement before they were asked all these questions about their criminal record. We've also seen in our job ad testing that trucking companies are regularly saying no felonies for the past 10 years, kind of categorical exclusions. And they may have some justification for some of them, trucking jobs may require port access or something like that. But even Department of Transportation background checks do not require that kind of categorical exclusion. So there's some specific kind of job areas we see some problems. But I think actually, and I'm going to echo a question somebody asked in the chat, I think it was Priscilla Tariquez, in the audience, one of the biggest things we see is that a ton of people are still getting turned away after the conditional offer. And sometimes that's just with a phone call, so the employers aren't following the formal procedures of the law. But even when they are following the formal process, we see a bunch of problematic patterns that undermine the degree to which I think AB 1008 is opening up opportunities. I'll just point a couple specific problems. The complexity of the fair chance process makes it ambiguous what employers can ask for after the conditional offer. And a lot of employers after that offer are asking incredibly broad questions like, have you ever been convicted of a crime? And this is kind of confusing to applicants who wonder, like, are they supposed to disclose incredibly old criminal records, which might not even appear on a commercial background check, or records that are dismissed and expunged, things like that. And then some employers are also asking for really detailed documentation of court and police records if an applicant wants to contest the withdrawal of a conditional offer. So I recently saw one company that asked for all the police records and court case records from the case. It's unclear why they would want those records and how we could guarantee that they aren't using them to circumvent the law, like considering arrests that maybe didn't result in conviction. So those are just a couple things, but I think the bigger problem is just that we can't tell if employers are actually conducting individualized assessments, and that's not at all transparent to applicants. And if I can take just like a couple minutes to share like one story, there's an African-American woman who we helped file a complaint about 9-10 months ago, after she was given a conditional offer from a major warehouse company. And she wanted this job super badly, so she had her packet ready to go. When she received that pre-adverse action letter, she was kind of unclear where she was supposed to send it. So she called a bunch of people and actually got completely wrong information, both from the background check company and from the company itself. They clearly hadn't trained their staff, one problem. But then she figured out how to submit the packet finally, and then she was denied anyway, like without any explanation of why her convictions were relevant. And to me, like the details of her convictions kind of matter in this case. Her original conviction stemmed from a police traffic stop, right? And when the police found that she had unpaid fix-it tickets and warrants from those, they pulled her out of the car and threw her to the ground and cuffed her in front of her kids. And then when she argued with them and said, please, can you wait to take me to jail until her mother can come and get her kids? Then they charged her with a kind of battery against a police officer. They took her to jail and later kind of added another felony count for another alleged incident that her car had supposedly been involved in. She couldn't pay bail, right? She was desperate to get home to her kids. And her lawyer told her, just look, plead guilty, you won't get any jail time, and you can get home to your kids. So she did, right? She says she wasn't guilty of either offenses, but she pled guilty because she needed to get home. And now that misdemeanor and felony conviction are standing in the way of her job, right? And why those convictions were relevant to the warehouse job duties, I don't know. Why they didn't consider her mitigating evidence and evidence of rehabilitation, I also don't know. But that to me illustrates this kind of fundamental problem that these kinds of arrests and convictions are still standing in the way of folks getting jobs. We filed a complaint with the FEH 9 months ago, and we still don't know whether AB 1008 can defend kind of her rights to a fair chance hearing for this job or not.
And
let me bring in Sandra here. What are some of the barriers that you're still seeing and issues with the law?
So, and I just want to talk about something that Jennifer said. Half the time when the employers are asking for all this information, they don't understand it when they read it anyway. Like you have to be trained to read information from someone's background. So a lot of them is just asking for it and not even understanding it. I think that's what I heard her say. If I sent my background, they wouldn't understand what it was, because the courts and all the legal, they have all these numbers, and they, and plus I learned from my background, what they do is, they have my criminal history looked really huge before I start cleaning it up, because it had it had all kind of stuff on it, and it had wrong stuff on it. It had names that I don't even, because someone else's birthday was my birthday, and I mean, it was a mess to get cleaned up. And so the question that you asked, what are some of the barriers that I'm still seeing? I'm seeing that employers, like Jennifer said, is asking, like, what are some of the barriers that I'm seeing that when employers are asking for proof of rehabilitation, is very hard. Like, people don't know how to find how to gather that information, you know. And then what I'm seeing.
Let me just interrupt you for a quick second to ask you to turn that phone off.
Oh, sorry.
Thank you.
I don't know how come it's coming on now. So let me just, okay.
Sorry about that. Thank you.
So what I'm also seeing is that this 5-day time that people are having to answer to those questions or to that information that employers are needing is just not enough time, you know. And then I also know that people are just looking for a job. When you come out of incarceration, you're just looking for a job. So you don't have time. If that job denies you a job, if that employer denies you a job, you're just looking for work. That's what you're looking for, you know, because you're in survival mode. You know, sometimes you need a job just to, you know, just to pay your bills. So instead of fighting, you know, they just move on to another. And I think the biggest barrier that they are running up against, they just don't know that they are able to do all this, they have the right to work. I think that's the biggest barrier, you know.
So we've identified, you know, particular industries, particular types of businesses where this may be especially challenging. Lack of, I think, individualized assessments and following procedures, as well as not enough time in the procedure to allow the spirit of the law to come to fruition. So I wonder if in our remaining 6 minutes or so, if I could ask all the panelists, if you have ideas about ways in which the regulations or the legislation could be developed to improve opportunities for individuals with criminal histories.
Well, this is Brett. I'll jump in on just a couple of thoughts, and I agree. Let me just first say I agree with all the panelists and all the barriers, right? So I'm with you on that. Even the ones where you can't even progress on an application unless you answer a question in violation of the Fair Chance Act. But we're going to what are some things we can do within, you know, regulations. I mean, a couple are, you know, we've seen the success of the DFVH's harassment prevention training, and perhaps, you know, something similar, you know, it should be thought of with regard to training employers on the Fair Chance Act, right? To make sure everyone's on board with how this works and the finer points. I mean, I think that's one, you know, a positive idea. I also think, you know, affirmative statements on a job application about the Fair Chance Act, you know, as a requirement are helpful to make sure, again, we're all on the same page. It's right there in writing, almost reversing ban the box, right? We've seen the box for, you know, however many, you know, decades, to try to reverse it with an affirmative statement of what the law, you know, is in terms of within the process that I think would be, you know, very, very helpful. And, you know, I think those are some improvements, as well as, I mean, as you pointed out, Adam, just again, to reiterate, you know, more explanation for the reasoning, essentially, you know, more to give the applicant to be able to have a better understanding of what's happening. So it's not just carte blanche. We looked, we're done, but some kind of, you know, more, so that these situations have more nuance and require a little bit more thought. So I mean, I think those are a few just big picture, but I think training key. I think something in writing on the application is key, and I think those would be a couple of proactive steps to move us within what the contours of what we can do, right, as opposed to a rewrite, so to speak. But I'll pass it to my co-panelists, please.
Yeah, I mean, I would echo some of what Brandon said. I mean, I would argue for actually an affirmative statement in job ads as well as in job applications, because I really do think that that is a signal to employers and people who are applying about what the process is supposed to look like, and that some required training, I think, would be really important. I actually think that we should require employers to use the DFEH forms that are on the website to communicate back about the individualized assessment too. Those forms are good. And they sort of lead employers through considering each thing they're supposed to consider.
Right.
And I think that would be really, really helpful.
Me too.
Sandra, let me round out or end our panel where we started with you and see if you have anything else you'd like to add on this question or anything else.
Are you talking to me?
Yep.
Okay. No, no, I think the other people speaking said it right, but what I really do think that would be great is if employers was trained on how to look at a person or what to do. I think training would be good for employers, because I know that a lot of them don't know. I know for me, when I was going in there, and it has gotten a little bit better, I guess. I really don't know, because I don't apply for a job. Like, you know, once they even sense that you have a criminal background, instead of them, you know, getting to know you personally, they just immediately shut down on you. I worked on the 1400 job campaign, and I seen that a lot when I was working there in Alameda on the 1400 job campaign, that they just, instead of them educating themselves about how, what the nexus is to the job that they have open, and how they just automatically shut down and say no, because they just don't know. So they need to be educated on that. So that's all I got.
Great. And any final thoughts, Jennifer and Brandon, before we come to the next?
I would add something. I think that DFEH should engage in some of the kinds of testing that we've been doing as a coalition to identify and reduce Fair Chance Act violations, right? When they're like out there in public, it shouldn't depend on the volunteer work of, you know, a bunch of folks like in our coalition to identify and then communicate, hey, you're in violation. So I think that's something that DFEH could take on.
Well, I would just echo Jennifer's comment, because I think the conundrum of the Fair Chance Act is that folks are in desperate need for employment often. And it's so challenging to go through a process when, as Sandra, Jennifer, folks are just trying to survive. So the idea of, you know, more front-end proactive work could have a much more, you know, have more impact on a broad scale, because of the nature of the inherent challenge of going through this challenge. When you're, like, for instance, I'm talking to folks who on Thursday who have been in prison for getting released after 30 years. You know, it would be challenging for them to pursue these complaints one at a time. You know, they're just trying to survive. You know, so I think, you know, this idea of what can we do on the front end to prevent discrimination may have a stronger impact on the Fair Chance Act's effectiveness. It could be another added tool.
Thank you all, and miraculously, we are exactly on time. So I'm going to hand it over now to Chair Mandelbaum, who will lead us through some questions and answers from the questions from the council members and answers from the panelists, and we'll open it up to public comment as well.
Well, thank you very much. It's a very enlightening panel. And as Deputy Director Romero just mentioned, we have carved out a period initially for council members to ask questions of the panelists in connection with their deliberations from what they've heard. And then we'll turn it over to public comment. And members of the public will have an opportunity to provide comments or ask questions utilizing the various functions. And I'll remind you again, you can use the Zoom raise hand feature if you want to provide your remarks directly, or you can provide written remarks either utilizing the chat box or the FEH Council. We ask that speakers' testimony is limited to 3 minutes to allow everyone to participate. So let's kick our post-panel presentation section off with council member remarks and comments. Do any of my colleagues have any that they'd like to provide? Councilmember Brodsky, I see your hand was raised.
I guess what's really concerned me in listening to the testimony has been what appear to be loopholes in the ability to, after the conditional offer is made, there seem to me that there are so many loopholes that just allow the employer to rubber stamp the initial decision. And I'm wondering if the panelists have any suggestions on how to close some of those loopholes, either legislatively or by the regulatory process. Because it just seems that in a way it's just delaying an inevitable, and rather than really nipping it in the bud. So, you know, whether that means tightening the defense and limiting the defense or what, and I'm seeing Jennifer nodding her head, so I'm hoping you have some thoughts on that. Thank you.
I wish I had clearer answer to that. I mean, I do think that is the fundamental problem. And this is a little bit of a question that Joshua Kim from the audience just asked too. I mean, part of the thing is, so what is direct and adverse relationship to job duties, right? How do we kind of codify that more narrowly for employers, right? So that it's not like any serious conviction is relevant to any job, which is, I think, what often ends up happening. So I think that, you know, some work needs to be done there. And I do think, I mean, one concrete thing, I guess two concrete things. One is to sort of have some, and I don't know if this is possible under the law as it is currently written, but have some monitoring of like who they're turning down and who, like how many employers are in fact reconsidering after that conditional offer stage, right? Like, so we have no data on what employers are doing statewide, like none. Like the data we have is like the job ad stuff that me and my students did, right? But like systematic data collection about whether employers are changing their mind after we don't have that. So I think thinking about how to gather that kind of data and how then to make a requirement that they use, document, and share their thinking in consideration for time since conviction, that they articulate. So what is the relevance to the job duties? There's a little, the DFEH form asks the question, like if they filled that out, at least they would be walking through the process and there would be some documentation that maybe folks later could evaluate. So that's just a couple ideas.
One thing that, segueing on that, just if I may, that occurs to me is I wonder if there's a model that we could look to in the interactive process that we apply in disability discrimination cases, where there has to be an individualized assessment, but it's after some interactive process occurs, so that there is more of a accountability, that we can track more accountability. I don't know, it's just a thought.
This is Brandon, and I would agree with your point, Councilor Brodsky and Jennifer. I mean, I think, you know, our ledge team, you know, could kind of craft things or have ideas, but I certainly think that's the area where there's the problem. It's that rubber stamping. It's, you know, there's really no reason behind it, and it just gives a way to say, okay, I complied, but did I really? And some other things like that we have in our toolkit, but maybe could use more specificity is, like, for example, you know, the rebuttable presumption, you know, in the regs on, you know, 7 years, and maybe there could be more to make it stronger than just a rebuttable presumption, but, you know, something else to provide. 'Cause that's the one thing I hear from employers often is there a line? You know, is there a clear cutoff that we should say this is it? And so maybe that's another thought is maybe that's somehow more strengthened to give some contours. And I don't know, but I just feel like those are some of the challenges I hear of how far are we going? You know, we know there's a rebuttable presumption, but, and then, you know, the non-explanation of reasoning, making it very difficult to challenge. So I think those are two areas where I think there's some gaps.
Well, you bring up a good point, and I want to go back to something Professor Tilton said, and in terms of the genesis of the Fair Chance Act and the negotiations that had to be made to get it passed, and that is going back to the look back period. So for people that aren't familiar with that expression, how far back are we looking into someone's criminal conviction history? And there is a rebuttable presumption and some degree of guidance that the older the conviction, the less relevance it gets. But I'd be curious to know what the specific concerns or pushback was on a clear, bright line look back, in light of the fact that we all know under California's consumer laws, background checks it cannot include any information that's more than 7 years old. So if one were to utilize a background check, they wouldn't see that criminal conviction history at all. So I was curious if you have some insight, Professor Tilton, I think you're on mute right now, but on what the concerns were about including that same enshrining that same look back period that's available in our background check laws into something like the Fair Chance Act.
Other people may remember the details of this better than I do, but as I recall, it was a real source of opposition for the Chamber of Commerce, and also maybe for some of the cities and counties who, of course, they get to see further back because they use DOJ background checks. So I think that both of those folks were, I think, pretty concerned about the hard look back period. What their rationale was, I don't even know that I knew at the time. Given the 7-year consumer report law.
Councilmember Ortiz, I think you're on mute, but yeah.
Yeah, I was just going to chime in. You know, obviously I have some affiliations with the Chambers of Commerce, and whether it's accurate or not, I will say anecdotally, there are concerns from employers that, you know, so for instance, if there's a news article about someone who's a sexual predator or has a violent history, sometimes it doesn't necessarily have a direct contact with the job duties itself, but will have a morale issue and may, in fact, have issues with regard to the duties with the coworkers. So there was a lot of concern expressed by Chambers of Commerce when these laws were starting to percolate about the effect in handling morale issues in the workplace and concerns by coworkers. Now, how we mitigate that, I don't know. Perhaps that's something the legislature needs to really think about.
Other Councilmember Iglesias, I saw your hand next.
Yeah, thank you all very much. This has been a fabulous panel already. I have kind of two questions. One is really kind of about the facts, and maybe Professor Tilton, sounds like we don't know, but I'm curious, you know, is there more either avoidance or a violation of the law by large employers, or is it small employers? Is there more by internet applications versus paper applications? Because I'm just thinking in terms of if there's going to be some targeted enforcement, it would be helpful to know where. And then the last part of that is, are there any like well-known employers that are clearly in violation that could be the target of an investigation so that that gets the word out?
Yeah, I think fundamentally to your first question, we don't know. And maybe some other folks know better than we do, but I don't think we know very clearly about the patterns, right? I do think the kind of visibility of the DFEH investigations and processes, right? Like, so I think it would be really helpful if there were publicized clear cases where DFEH processes have completed and they've won resolution for folks. And I don't think those have not been a few of them, I think some cases have come to the completion, though, oh boy, is it a long process, right? But there's not been a lot of publicity around that. So I do think that would be really helpful. And yeah, there are some major companies who I think are in violation, and I guess we'll see if some of those get completed soon and can be publicized. But I do think identifying some of those major companies would be helpful. Yeah.
Can I just also do the converse? Maybe it would be helpful in training to publicize employers who are abiding by the law. And, you know, I don't know, Brandon, if you have examples of that, if you've come up with those, but of course they'd have to be, you know, they'd have to want to cooperate and coordinate with you on it, but that might be a strategy also for getting the word out.
Yes, you're correct. And I think even in our panel discussions later today, there'll be some highlighting of employers. But I would agree broadly to this point that there's something to be said about training here. You know, wherever we, you know, what happens, I do think that's something that's been hit upon a lot, that there needs to be, you know, more training, and also bringing in examples of, hey, it's working, because they've also measured some of the successes of hiring formerly incarcerated, right? So there's a lot of good data around staying on the job for long, dedicated workers, and many folks that will even be sharing this discussion today will highlight that. But I would say on top of that, I agree with you, that it's great to highlight the successes, but it also to me reinforces kind of broadly, you know, employers need training, because we're hearing from both large and small, we see issues. And the other thing I would mention is a lot of the stuff is outsourced to people in other states, and you know, their lack of knowledge is not, they're not really tuned in. Now, it's not an excuse, but just showing again that training being a tool as people outsource background checks.
I would like to mention that it's important to underscore good practices and policies, but I'd be careful about making blanket statements or assurances that certain companies are following the law. I think we could identify individual practices or policies. But one thing I wanted to add and question any of the panelists is whether or not you have seen anecdotally, because it seems like there's no data, when an individual is provided an opportunity to provide additional information within the 5-day period, do we see any different decision being made by the employer? Do we have, and I know we don't have data, but what are your thoughts on that? Professor Tilton or Sandra Johnson or Brandon Butler?
I mean, I do know of a couple of cases that we've supported people in providing additional information and they have gotten the job, but I also know of a lot of cases where they haven't. So yeah, it's hard to say.
Is there anything in particular that you could identify with regard to information that's provided to the employer by the individual in terms of when he or she submits that information or what is contained in that submission that could be helpful to other folks?
Well, from my understanding, when you have to give rehabilitation, what I did, I would gather letters of recommendations from people that knew me from before I got my life together, and I would and letters from people that I collected all kinds of letters of reference. I went to college and I was real open about my history, so everybody was willing to give me letters of recommendation. But that's still getting, and I'm not sure if I answered you right, getting that criminal history or getting that rap sheet takes way more time than 5 days. So the bottom line, those 5 days, if something could be done about those that 5-day period, it's just not enough, and people get discouraged with that, and if they don't know, I was lucky to have a network of people and have friends and mentors that kind of helped me along, but everybody doesn't have that, and I was really open about my criminal history, and so everybody likes to help someone succeed, and that's what happened with me. But
given your experience, Ms. Johnson, how many days do you think would be sufficient?
I don't think that weeks, because I think when you send off for your when someone asks me, so say for instance someone asks me, hey, prove your rehabilitation, I would have to contact people. I would, if I didn't have it, I would have to contact them, ask them for a letter of reference. Everybody won't get on it. You have to keep nudging them. Then I would have to get my background. I would have to see what's in my background and see what they see. You have to go take fingerprints and then have it sent to you. Some people have to pay for their criminal rap sheet. Some people don't have the funds to do that. It's just a lot to gather. I don't know. I just had a lot of people helping me what to gather, and I had started gathering. And then you have to get certificates. You have to gather all your certificates that you got. So I kept a lot of my certificates from when I was incarcerated because I was really proud of getting them and going through the programs and stuff. But it's a lot. So you have to ask Jennifer how much.
Oh, I don't know. I mean, I think actually, we've been, because it's not enough time, and even 10 days, which I think maybe we were originally fighting for, is not quite enough time either. So I think, we're trying to train people to prepare them way in advance because it's the only, and I do think, the one thing, I don't have concrete lessons, but I would lift up what Stacy put in the chat, that having, and what you said as well, having people help you with those letters is really important. Right? Because they can be made better. Sometimes people are hesitant to fully explain, and just adding another sentence of kind of, who they are now and how they've changed can make a real difference to employers, I think. So I think having that support, and Legal Aid at Work has developed this new kind of packet with, sample tips, which I think is really helpful.
I've had to help clients get documents, rap sheets and stuff, and you have to sometimes go back to court and get the certified copies. It can literally take months, if, and sometimes on occasion longer, but certainly months, not days.
Well, Well, I think, and I think that emphasizes the need to have that packet available, because on a practical level, employers cannot be expected to wait months when finalizing their hiring processes. So having that in advance, I think, is going to be critical, just given the reality of the delays. I want to turn it over because we're running out of time. I want to make sure our members of the public have an opportunity to provide remarks and to ask questions that they have. I know we've had some in the chat function, and we can read those out afterwards, or ones that haven't been responded to at least. But I'll turn it over to Deputy Director Romero in terms of whether people have hands raised or have emailed.
Sure, I see one raised hand from Terry Curd, and I'm now going to unmute you. One.
Oh, you're on mute. Oh, it's on mute.
Sorry. Okay, so the problems that you're talking about have been addressed by the company that I work for, CEO, which is the Center for Employment Opportunities. And what we've done is erased some of that issue about applying for a job. So what we offer is transitional work so you can earn money while you're looking for a job. And then we have a team of folks who will help you find a job with background-friendly employers that we have. And then we have a year-long retention program where we help advocate for you when there are problems. And I agree that most folks who don't come through our program have the problem of not knowing what their rights are. So they just kind of give up. If somebody says, okay, you're fired, they're like, okay, and they look for another job. They have no concept of building a relationship or understanding that you have rights of your own. And so we're trying to alleviate that problem. The other problem is the education of the employers, and we're starting to build a program for that so that we can explain to them what it means to hire someone with a background. Okay, it's all about education and our verbiage. You know, we try to say returning citizens a lot instead of people getting out of prison. You see what I'm saying? We need to change the narrative of how people view them. So, you know, they were talking about employers that might fire you because, you know, there's a fear of, you know, association, whether it's with their customers or with the other employees. And that's because there's no understanding.
Thank you. Any other raised hands?
No additional raised hands, but I'll take this moment to read a question from the chat box from Claire Irvin Lee. Could DFVH provide training to incarcerated people who are close to being released? Perhaps some kind of program to help inmates create the packet so that they have it prior to their release?
Yeah, I'll go ahead and answer, because I think that's a great question in terms of what more can be done when folks are inside. I mean, I know here what we've been doing, like I said, you know, the video you saw airs on Inmate TV, so it's at least kind of like a regular infomercial that's playing in all California state prisons, as well as we do trainings, and like we're doing this week for folks who are getting out. So we do try to partner with CDCR and you know, get training, but I think you have that next component of kind of helping that packet development. I know various reentry organizations do go inside, and now with COVID, it's been, you know, a major challenge, of course. But, you know, I know Sandra does, you know, works to this. So a lot of folks are going in and building it. But Sandra, if you want to speak to what's happening, but I agree with you that's important to work with folks as they're getting out.
One other thought that DFVH could do in terms of training would be to focus on public defenders' offices and send materials, because if they have, you know, that's an easier source to go back to obtain court records showing what the person's criminal record is, for example.
You know, I agree. I think it's important to, you know, we've actually, you know, even with, we have worked with public defenders, but I agree that's an important group, as well as kind of everyone involved, you know, in that process. Why we work with parole agents, probation agents, public defenders, because yeah, everyone there is really on the front lines of this problem, you know? And so I think that's one of our key strategies, is kind of helping those folks identify. And, you know, we've seen some of our complaints go up, but I think that's a crucial tool, is working with the advocates and folks who are working with folks here now on identifying violations of the Fair Chance Act.
And I just want to say that's what I do when we were going in. Of course, COVID happened, so we had to flip everything over on correspondence, but I still get letters. We ask the participants to write us letters. I answer all questions because I get a lot of letters. Hey, I'm getting out, I'm afraid, like I need a job, how do I do it? So I take those letters and I answer them personally, but that was one of the presentations that we really focused on when we were in there, is getting them prepared. And I did explain to them, I mean, I did let them know that I started, like, that's why I told them to save their certificates, any certificates they get in there for any kind of classes, self-help classes and stuff. And right away start building your rehabilitation folder. Like I would say, make a portfolio and any letters that you can get, ask people. And then the one thing that I would also, you know, say, ask people that know you and knew you from before, and then you get to know right up front. Say, hey, look, I'm looking for a job. Might need a letter of reference. Are you willing to do it? And so that is one of the things that we really, I really talked about in there, because that's what I did.
And let me read another comment from John Boudet. It seems the Fair Employment and Housing Council regulations assume there is always a single reason for disqualifying someone based on their criminal history. Many times, for example, if there was a single misdemeanor from 2014, it would not be considered relevant. But if there are also cases from 2017 and 2019, each of which by themselves may not be a disqualification, but together they show a pattern of and determined to pose an unacceptable risk, of course, offense severity and job relatedness would be considered.
Well, I'll take that just in terms of the FEHC regs, and I appreciate that comment, and I don't disagree with it, and I don't think the regs disagree with it. The regs, I believe the ones that you're referring to are the ones that apply in terms of the balancing act and of what to consider about criminal history, namely the date, you know, how far it's removed, the job relatedness, severity of crime, things like that. And I think certainly the regs should not be read to assume that there may not be multiple reasons or a totality considered. And so generally speaking, I think I agree. I appreciate the comment, and I agree that that may be the case. And I don't think the regs should be read to disagree with that conceptually.
I'll now read a question from Priscilla Tariquez. I do want to share that 3 to 4 of the instances of my experience had to do within San Bernardino County, since I was applying to county jobs. Is the law different for specific counties?
Right, the California counties and entity employers have to comply. I think there was a reference to what background checks are available, but they still are limited by the same constraints in terms of only utilizing convictions and to making the balancing act about how they use convictions and complying with the due process components of the Fair Chance Act. So that there isn't an exception. There are obviously positions within both the public and private sector that have different requirements, such as peace officers being one example. So that's its own issue. There are certain public employment positions that may have more constrained requirements, but generally speaking, public employers are covered by these same requirements.
Let me now ask 2 questions to the department from S. Guillory. I wanted to ask what evidence DFEH needs in order to substantiate a claim. And from Joshua Kim, what is the agency's position, if any, on the background check company adjudicating pass, fail, pending on behalf of employer using a conviction matrix?
Well, just in terms of the conviction matrix, I'll say this kind of previews our next panel, which you won't want to miss, about the state of empirical research, and not that there is such a matrix, but how to kind of consider these things and what empirically goes into that process, and alternative approaches to outsourcing that, essentially, to how employers cannot be in the bind of having to make this complicated analysis for themselves, or what guideposts there are. That's something that I think the next discussion will be interesting and illuminating regarding. So I can't answer with respect to the agency. I don't know that there is a particular position. I will say that employers are ultimately, the buck stops with them as the hiring entity. That doesn't mean that they can't rely on background check companies or other third parties to assist them in that process, but the buck stops with them. I think this is a really complicated area, and it's something that came up a lot in the public comments for our regulations, in that obviously the brighter the line, the easier it is to comply. And so there's a temptation there, and it's a warranted temptation in certain respects, to have some clarity and not put employers in a bind. On the other hand, we know that bright lines fundamentally fail to capture the myriad circumstances of individual employers. So it's just very, very difficult to say categorically that certain crimes and certain dates of crimes are, apply for certain positions and ones don't. We've seen that in just the simplest context that we were talking about before with respect to look back periods. And, that would be the simplest of bright lines of kind of, is there a date that we can cut off consideration of convictions? And even that, for reasons that I think have been expressed by Councilmember Ortiz and others, is hard to implement in a way that doesn't lead to perverse results or problems. And when you talk about a conviction matrix involving, a bunch of crimes and a bunch of different jobs, it gets that much more complex to do. But we are out of time, and what I hope is there are certainly some additional chats that depending on the panelist availability, we can respond to, and I hope folks stick around, because we will have another Q&A session after our second panel, and then a third after the presentation in the afternoon. And so if you haven't had an opportunity to, you can continue our discussion, but I want to make sure we stay on our schedule. And so now we're going to take a short break, just from 11 to 11:15, so you can get up and rejoin us at 11:15. And like I said, this is going to be a very, very interesting panel with two esteemed academics about the state of empirical research. So we hope you join us, and we'll see you back at 11:15.